Sorry, my line went off, so I have to start all over again. Sorry. Yeah, so those who have just joined us, as I indicated earlier on, that tonight we first want to continue with our discussion of the people that we did not finish discussing yesterday. That is the mock exams by those who are studying at the campus. And when we are able to finish that, and we discuss course structure, and then we engage the homosexuality. So we're looking at question 8, that the requirement of a has been modified by Ghana Supreme Court. In the decided case of one of the cases is correct and the other one is wrong. Yes, we know the answer right away, that just by maybe reading page 4 of Mrs. Zona Hamon's law of contract, you will notice that at the footnote 9, the case is mentioned over there, but I was just trying to mention or explain what we mean by a seal in the deed. That a seal is just a mark of authentication, a mark of giving the highest level of approval to a document, so that if your seal was found on a document like a deed, the document could be taken at its face value. And that is why we have the maxim that a contract under seal is enforceable without need of consideration, whereas a simple or parole contract is not enforceable unless there is a consideration. The reason for not requiring consideration for the enforceability of a contract under seal simply means that a contract under seal, by reason of the seal, right? By reason of the seal, it means that both parties have put their seal on the document. And because both parties have put their seal on the document, it is putting beyond doubt the fact that both parties actually agree to what the document is saying. And that is why we have the proposition that for contract under seal, there is no need for consideration. But for simple contract or parole contract, which does not necessarily have to be in writing without the seal of the parties, there's a need for consideration, subject to the modification, which we have seen in Act 25. But that is not what we are talking about. So this was just like a footnote remark. So coming back to the case, as I said, if you've been looking at the Mrs. Zona Hammond, if you look at page 4, footnote 9, it's there that Owusu-Asiedu against Adomako and Adomako. The court indicated that if you have a deed, it need not be sealed so long as the signature and attestation, that is witnesses, to say that they saw you signing it, so that the attestation, the witnessing of your signature will serve the same function as the seal, because the seal did not necessarily need to witness. The seal was enough. So the court is saying that even if your seal is not there, but then have like your signature, and then we have people to testify or who have testified on the document that they saw you signing it, it will have equivalent effect of the seal. And that is why there's no need for this. In the case is the Owusu-Asiedu against Adomako and Adomako. If you look, so obviously the answer will be C. Yeah, the answer will be C. Now, if you look at how the examiner has actually put the questions, he or she is attempting to trick you. So look at the various rendition of the cases. Look at A, Owusu-Adomako against Adomako and Asiedu. So let's say that if you even know Owusu-Asiedu against Adomako and Adomako, if you're not careful, right? And that is why there's a need for significant circumspection or caution when you are dealing with multiple choice. And that is why some of you have done the exams 2 times, 3 times, 4 times, 5 times, and even 6 times. You haven't passed and you are still struggling to pass. It's not so much the case that you probably haven't learned, but you need to pay attention to some of these things. The multiple choice are probably just about 20 questions or so. I think there is it. Are they 20 questions or so? And you get the answers. Some of them look similar, and some of them are just meant to trick you. But if you don't open your eyes well, that's why the fact that you know it, you go for the wrong option. And question 8 is like a good example. Look at it. The right answer is C. Owusu-Asiedu against Owusu-Adomako. 2007-2008 Supreme Court of Ghana report 591. But if you look at the A, for example, A, it looks like the C. So that as soon as you saw Owusu-Adomako against Adomako and Asiedu, you do not take your time to test the correctness of your choice against the other remaining, you get it wrong. So that is the advice that I will give you. And of course, unfortunately, this is also the type of case in which the type of question, either you know it or you don't know it. Yeah, so some of the multiple choice are like that. There's very little room for manipulation or juggling to get the correct answer. Okay, so 9, which of the following is a bar to rescission? Yesterday, we explained that rescission is an equitable remedy by which you set aside a contract so that a contract in respect of which rescission can be decreed means that it is a voidable contract. A voidable contract simply means that a contract which is valid and binding for the time being, unless or until it has been set aside at an option of a party, may be affected by a vitiating factor, be it mistake, misrepresentation, or duress, as the case may be. So that is a voidable contract, and one of the remedies is rescission. But this rescission, being equitable remedy, may not be available in some cases. So there may be a bar, there may be an obstacle to its availability. What are some of them? Let's look at the options they have. A, absence of consideration. Of course, you have to know that that is no. Consideration has got nothing to do with the availability of the rescission. And especially so, we look at our own jurisdiction in which consideration has been whittled down significantly, so much so that's not really important in a number of cases. So A is not the answer. B, lapse of time. Lapse of time certainly is a bar to rescission, meaning that if there has been inordinate delay, undue delay, just like the Live against at the International Gallery, about 5 years or so, the court said that that was a long period of time for rescission to be available, so rescission could not be granted. Affirmation of the contract. Affirmation of the contract simply means that, let's say that you enter into the contract as a result of operative misrepresentation. You become aware of the misrepresentation. That is, you discover the fact that you have been victim of misrepresentation. Nevertheless, you ignore it. You seem to have ignored it and go ahead to continue to observe the contract, despite having become aware of the misrepresentation or the appropriate vitiating factor. Then you have affirmed the contract. Because you have affirmed it, you cannot later on ask for rescission. So coming back to the question is asking us to pick which of them not a bar, which of them will not prevent the grant of rescission. So certainly A, because A, as I said, consideration, whether present or absent, has got nothing to do with the grant of what? Rescission. Yeah, so the answer will be A. And again, as I said, you need to exercise circumspection. If you, for example, don't read the question, well, as soon as you say that what you're referring is not a bar to rescission, you probably don't pay attention to the note, but you're even fortunate that the examiner has even boldened the note, drawing your attention to the fact that he's talking about the odd one out, right? So the following are bars to rescission. Pick the odd one out. That effectively, that's what the question is saying. But like, if you don't read it well, you just, as soon as you see lapse of time, then you go for that. But that is not the answer. The answer is which of the following is not a bar to rescission. Yeah, so the answer is absence of consideration. Is there anything somebody is saying? Can someone assist by providing possible answers for question 1 to 7? Oh, question 1 to 7, we discussed that yesterday. So go back and play the recording, or if some of you were present, you can play it. Otherwise, we'll be repeating ourselves and we are not able to finish. As some of you would like us to move very fast. I know some of you would like us to discuss all questions which are available in Ghana before you go to write the exams. So they like us to go through everything. That is what some of you have told me. So 10, what is the standard of proof required for the prosecution in a criminal case? Yeah, so you know that when we're discussing Ghana legal system, and then we sought to distinguish between a crime and a civil wrong, right? And for that matter, a criminal case and a civil case. And one of the points of this distinction is the standard of proof, right? The standard of proof, the level of proof, which is for you to make up the case against, let's say, the accused person, the case like the criminal case, and then for you to make the case against the defendant in the case of like civil litigation. So we know that in a civil litigation, the standard of proof is preponderance of probability, right? If the question, for example, if it's about civil case or civil litigation, and say what's the standard of proof, and one of the answers is, let's say, balance of probabilities. Another question is the preponderance of probabilities. Please go for preponderance of probability because that is what the evidence access. Despite the fact that if you look at the law of evidence literature from UK and other common law, they still use the language balance of probability, but per our evidence act, we prefer preponderance of probability in the case of civil case. But now we are talking about criminal case. In criminal case, as Article 19 of the Constitution tells us, the standard of proof is what? Proof beyond all reasonable doubt. So let's look at where is my Constitution? Yeah, so if someone has, Article 19, I think Article 19 clause what? You're supposed to be expert in the Constitution. I'm going to ask you to read the 10 a day. I'm sure those who heeded the advice, I'm sure that you have finished reading the Constitution. What provision under Article 19 speaks about the standard of proof? Anybody? No, I'm not talking about the answer. I said, what provision? What provision? Yeah, we know the answer, but I want us to go to like the source. What provision? Clause what? You are supposed to be reading the Constitution, not me. What provision? Clause 2. Clause 2, paragraph what? A person charged a criminal offense shall be presumed to be innocent until he is proved or has pleaded guilty. But that does not exactly state the clause 4. Okay. Whenever a person is tried for criminal offense, the accused person or person authorized by him shall, if he so requires, be given. Hey, who is throwing us away? Clause 4 has got nothing to do with the standard of proof. Let me. We go to the evidence act rather. There's a presumption of the innocence. What is the provision? If you are charged with criminal offense, you are presumed to be innocent until anybody. Yes, administrator. Just getting worried. Wow. Yes, please go ahead. And somebody, why are you just throwing out? Somebody said what? Clause 13. Clause 13, yes, administrative.
To see.
Yeah. Oh, sorry. Sorry, you can unmute yourself. You can unmute yourself.
Article 19, clause 2C.
Clause 2C. Yes, until he's proved or has pleaded guilty. Okay, so that's a presumption of innocence. Okay, section 13. But, okay, so the person who said clause 13, he meant the evidence that, okay, that is fine. Okay, that is fine. So is the standard of proof is the proof beyond all reasonable doubt, proof beyond a reasonable doubt, proof beyond reasonable doubt. Why do you say that accused person guilt should be proved beyond a reasonable doubt? It's the accused person who can, if his guilt is established, he can raise one reasonable doubt. If he can raise one reasonable doubt, that will collapse the case. So it's rather the when there's a reverse burden, but not, yes. Administrator, go ahead. Yes. You can unmute yourself. You can unmute yourself. Can somebody read section 13C of the Evidence Act for us? Evidence Act 13C. Can someone read it for us? Okay. All right. I've opened it myself if you not read it. Good. So let's start from 13. It's headed proof of crime. So that is a standard for proving a crime, whether it's in a criminal case or civil case, so long as anything crime come up. The standard of proof with 13.1, in a civil or criminal action, the burden of persuasion as to the commission by a crime, by a party of a crime, which is directly initial, requires proof beyond a reasonable doubt. Okay. 2, except as provided in section 15C, in a criminal action, the burden of persuasion, when it is on the accused as to a fact, converse of which is essential to guilt, requires only that the accused raises a reasonable doubt as to the guilt. Okay, so in that respect, A, beyond all reasonable doubt. B, proof beyond a reasonable doubt. C, proof beyond reasonable doubt. So the devil lies in the details. And of course, the provision that we read, the 13.1, says that the standard is a proof beyond a reasonable doubt. So meaning that the B is the answer, because that is a direct language which is used, except that in everyday parlance, we tend to say the A. But like if you look at the language of the law itself, it's like the proof beyond a reasonable doubt. So these are some of the tricks which can sometimes land us into trouble. Okay, so let's move on to somebody has written something for a reasonable doubt. Not, yeah, so we said that that is B. Hubert. Yeah, so that is B, isn't it? A proof beyond a reasonable doubt. Okay. So let's go to 11. Akosa enters in a contract to sell his Mercedes-Benz to Kojo. Kojo has gone to see Akosa to pay for the vehicle, but Akosa is refusing to accept the payment, claiming he was not of sound mind when he entered into the contract. However, the fact of Akosa's mental challenge was not apparent when they entered into the contract. Choose the best for the parties. Okay, so before we look at the answers, briefly, who can tell us the area of law? Hubert. Yes, anybody? Levin. Okay, capacity contracts. Okay. All right. So it's capacity contract, but we are the focus is now on those who are mentally deranged or lunatics. Yeah, so that is the aspect which is relevant. And we know the law. The position of the law is that there's a presumption of corpus mentis on for everyone. Everyone is presumed to be mentally sound. So that is a presumption, but it's a rebuttable presumption, meaning that an evidence can be adduced to actually demonstrate that you were mentally deranged. But here is a case that there's a reverse burden of proof, as it were, because A and B has entered into a contract, and if B is alleging that the contract should not be enforceable or whatever, because he lacked corpus mentis, he lacked a soundness of mind, then he will have to bring evidence to show that at the time that the contract was made, he was not corpus mentis. And then the burden of proof will change or will swing back to the other party who is seeking to enforce the contract, where for him to prove that the other party really was corpus mentis due to X, Y, Z, and so on. Okay, so based upon that, let's look at the option. Akosan will have to sell the vehicle to Kojo because the contract is voidable. Saint Mugai, yeah.
Yeah, so I want to ask a question. So in the proof of corpus mentis,
Yes.
should it come from the person who is suffering from that to claim that I am in this condition, therefore I cannot take a certain decision, or it must be proved that when the money was to exchange hands, he was in that condition, but not he himself saying I am not in the best frame of mind, so I can't take the money in this scenario.
No, so no, like we will have to put the Evidence Act in the context of contract law as well. If you look at the Evidence Act, everyone, as we said, is presumed to be of what? Of sound mind. There's a presumption of corpus mentis. Then if you look at the section, my evidence students, if you look at the section, yeah, what provision of the Evidence Act raises the presumption of corpus mentis? Anybody? Yeah, section 104. A person has a privilege to refuse to disclose to any other person. No, and that's and then there's a direct provision which says that everyone is presumed to be of like the sound mental health. Yeah. So if you look at the case of Imperial loan, yeah, Hubert, your hand is up. Okay. Yeah, Hubert, go ahead.
Oh.
Yeah, Hubert, go ahead.
That's section 42 of the Evidence Act.
Section 42.
Yes.
Right. Can you read it for us?
The person is presumed to be of full age and of sound body.
Presumed to be of full age and
of sound body.
Of sound body. Okay.
Sound body.
Okay.
Okay. So sound body includes the mind as well. So that's the relevant solution.
Okay. All right. So so coming back to the question which Saint Mugai raised. If a contract is made, right? Let's say let's use the facts of this question. Let's say Akosa and is it the Kujo? And the story is that they made a contract to sell Benz to Kujo, and then Kujo has gone to see Akosa to pay for the vehicle, but Akosa refused to accept payment, claiming he was not of sound mind when he entered into the contract. Okay, so he is making that claim that he was not of sound mind. So he's now become, if you like, aware of himself. Don't forget that there's what we call the lucid interval, right? So the fact is that the fact of Akosa's mental challenge was not apparent when they entered into the contract. Okay, so now Akosa will have to saying that, well, I was not compos mentis. So he would need to bring some evidence to show that at the time that the contract was made, he was not compos mentis. Then the other party will also have to rebut that, bring evidence to show that due to X, Y, Z and all that, everything. Yeah, Hubert, your hand is up again. Hubert, is your hand up?
That's a mistake.
Oh, right. Yeah, so let's come back to the specific. Now, of course, if you can actually, if you're mentally deranged, the contract is voidable, meaning that you can have the contract set aside, as it were. But who bears like the burden of proof? As I said, the law takes the view that everyone is compos mentis. And let's look the case of the imperial loan against Stone, where the court made the point that unsoundness of mind would be a good defense to an action upon the contract if it could be shown that the defendant was not of capacity to contract and the plaintiff knew it. So the person claiming that he was not of sound mind, he need to point to information which will confirm that. And that is also not enough. He also need to bring other information to show that the other party knew. The other party knew or ought to have known based upon the circumstances that he was not of sound mind. If that is made out, then he can actually have the contract or the set aside. So if you remember what happened in the imperial loan case, the plaintiff issued a promissory notes. I mean, the defendant issued a promissory note, and the plaintiff, that's the imperial law company, sued to enforce it. And when the enforcement action came, the defendant put up the defense that at the time that he issued the promissory notes, the plaintiff was aware of his insanity, that he was insane, and then the plaintiff was aware of that. Now the plaintiff, that is the loan company, deny knowledge of this so-called insanity. But this was a jury trial, and the jury made a finding that as a matter of fact, at the material time of the conclusion of the contract, the defendant was insane. But of course, the jury were not unanimous as to whether the plaintiff knew of the defendant's insanity. The jury were unanimous that the defendant was insane, but the related issue as whether the plaintiff knew of this fact of state of insanity of the defendant at the time that the contract was made is something that they could not agree upon. Nevertheless, the trial judge gave judgment for the defendant, meaning that the trial judge said that the plaintiff could not enforce the promissory note. But when the matter went on appeal, the English Court of Appeal reversed that decision, coming to conclusion that whenever a plea of insanity is made to justify a plea of a lack of capacity so that you can escape from the effect of the contract that you have made, you needed to meet the two twin tests. The first one being that you bring in evidence to show that at the time that the contract was made, you were of unsound mind. And secondly, the other party knew that you were of unsound mind. So these two must be satisfied. If you show only the fact that you are of unsound mind and you're not able to show that the other party knew of it, you will not succeed in getting away with the contractual obligation. So I think that that is the position of the law. Yeah, so the person who is alleging the defense, and oftentimes when it comes, I mean, this is a defense, isn't it? And oftentimes when it comes to defense in the various areas of the law, and this is not the exception, when it comes to defense, when you are setting a particular defense, you bear the burden to at least the initial part of the defense to raise a prima facie case, if you like, for the viability of that defense. And then the other party will have like the reverse burden to negative the defense that you have raised. So in this particular case, it is the accuser who has the burden to show that he was mentally unsound and yeah, and then the Kojo knew about it. So let's choose the best advice for the parties. A, accuser will have to sell the vehicle to Kojo because the contract is voidable. We'll go for that. We don't have enough information, right? But let's go on to B. Accuser can refuse to sell the vehicle to Kojo because he was insane when they entered into the contract. Now, as it is now, the information that we have, it is not enough. But let's move on to C and D, and before we come to pick the accuser can refuse to sell the vehicle to Kojo because the contract is void. Insanity certainly does not make the contract void, so that is not really applicable. Accuser will have to sell the vehicle to Kojo because he did not appear insane when they entered into the contract. Okay, so if you look at the scenario that we have, we are told that the mental challenge which accuser is alluding to was not apparent, meaning that it is telling us that, of course, and this will even the twin test is somehow embedded in this statement that the fact of accuser's mental challenge was not apparent, meaning that the twin test has not been satisfied. And if he has not been satisfied, then he's bound by the contract. If he's not been satisfied, then he's bound by the contract. So accuser will have to sell the vehicle to Kojo because he did not appear insane when they entered into the contract. Although we have very limited facts, but if you interrogate the facts carefully, you make a lot of logical deduction from here. Let me, I don't know if okay, let me do this way. Okay, so let me, you can make a lot of logical deduction. Good. Like, however, the fact of accuser's mental challenge was not apparent when they entered into the contract. So since we are told that the fact that Akosa was probably of unsound mind was not obvious to Kojo, right? What that means is that the twin tests contemplated in the imperial loan cannot be satisfied. And if it cannot be satisfied, then what that means is that the contract between them was valid and the defense of insanity will not avail. And if it will not avail, then the D will be the correct answer. Let me look at what you put over there. Okay. Yeah, I think almost all of you got it. No, but somebody said A. Okay, so Lily Kumsen, can you explain for us why you opted for A? Lily? Lily, why did you go for A? You can mute yourself.
No, Doc, I changed my mind.
Oh, right. Okay.
Yes, I changed, so I put it there.
That's fine.
Okay.
All right. Now, question 12. Which of the following is not a prerogative rate? Which of the following is not a yeah, you know the prerogative rates. The prerogative rates are the remedies which the court grants when it comes to the judicial review and also enforcement of the fundamental human rights and freedom, as it were. And the certiorari, of course, if you don't put it in the context of judicial review, it could be a bit misleading. If you are looking at it from the point of view of enforcement of human rights, because when it comes to enforcement of human rights, injunction can be granted, but it's not a prerogative rate, right? It's not a prerogative rate. But if you are going by traditional judicial review and orders which are made by the court, that we call the prerogative rates. They are certiorari, habeas corpus, quo warranto, mandamus, and yeah, and well, prohibition. Yeah. So 5. Certiorari is a prerogative rate issued to quash a decision or exercise of power where same has been made against maybe grounds of natural justice or deuterum partem, that is here both sides, or nemo judas in casa sua, the rule against bias, or don't be a judge in your own cause, or where you have given a decision which is against Winsbury reasonableness. That is to say that, as was stated in the Council for Civil Service Union case, that the decision is so irrational, right? So irrational that no person who is vested with discretionary power would have, for example, apply his mind to make that decision. So if you also abuse the rules which govern proper exercise of discretionary power under Article 296, I think. Article 296. I'm an old man. I learned constitutional law so many years ago. Yeah, 296. If you exercise your discretionary power against the principle which govern the exercise of discretionary power, that you have to be candid, fair, and then come out the predetermined rules and so on and so forth, then what you have done could be amenable to be quashed on judicial review by certiorari. Or habeas corpus. Habeas corpus usually relates to where someone is being detained, right, without a lawful order. It means like they produce like the body. Habeas corpus sub judicendum, yeah. And then we also have like the mandamus. Mandamus is where someone is clothed with authority, right? It's clothed with power to make decision or to take certain steps. And he or she alone has been given that power under the law, but he or she is not exercising that power. And for that matter, somebody's right is affected and all that. You could go to court and get an order of mandamus to compel the person to exercise the power. Then we also talk about like prohibition. Prohibition, someone or a court is entertaining a case or a matter in which it does not have jurisdiction, or in which it is abusing the principles of natural justice and so on. You could go to a higher superior court. Let's say that if it's the high court, you go to the Supreme Court to get the prohibition against the high court. Or if it's like a lower court, you go to the high court to get the prohibition against that lower court, as it were. And then quo warranto. Quo warranto simply means by what authority are you doing what you are doing? So where someone is exercising, is purporting, right? Let me put that, is purporting to exercise power or authority, which he or she does not have, then you can go and get another quo warranto to let him come and explain the basis of the power that he is purporting to exercise. So those are what we call like the prerogative rates or prerogative orders. So if you look at it, injunction is not one of them. So injunction, that is a 12C, will be the answer. I earlier on made the point that when it comes to enforcement of fundamental human rights and freedoms, the prerogative rates are also applicable. So if you look at Article 33 of the Constitution, for example, Article 33, Clause 2, the provision says, and I quote, the High Court may, under Clause 1 of this article, issue such directions or orders or rates, including rates and orders, in the nature of habeas corpus, certiorari, mandamus, prohibition, and quo warranto, as it may consider appropriate for the purposes of enforcing or securing the enforcement of any of the provision on the fundamental human rights and freedoms, to the protection of which the person concerned is what is entitled. Okay. Yeah, but as I said, the High Court can also issue injunction for purposes of enforcement of what human rights, as it were. And that is why, if we look at the 33.2, it says that may issue such directions or orders or rates, right? Yeah, or it can be like the combination of this, as it were. But the fact of the matter is that injunction is not a prerogative rate. Let's move on to Mesa puts a notice on the law of faculty board. And there's a mistake. Put a notice on the law faculty board or board of law faculty, and it reads, quote, brand new sale of books, sale books textbook, or 650 now 300, selling like hot cake. Contact the stated number. This is, yeah. So this is the advertisement which has been put on like a notice board, and we are invited to determine the legal effect of that advertisement. We know that advertisement is of two types. We have advertisement which is in the nature of potentially unilateral contract. That is to say that it requires a particular act to be performed, such as what we saw in the Carly against Kabbalah smoke ball. If you buy the product, you use it according to stipulated way, and 2 weeks time you get the influenza, we're going to give you compensation of £100. So that is unilateral. Or R and Clark, Gibbons and Proctor, Williams and Coward, in those type of cases, Fitch and Senedeker. Then we also have the advertisement, which is in the nature of a potentially bilateral contract. A potential bilateral contract, in that case, what it means is that the advertisement is an invitation to trade, requiring anybody who may want to respond positively to the advertisement to come forward and make an offer, which may be accepted or rejected. So that is advertisement, which is the nature of a potentially bilateral contract. And so we need to find out, if you look at this advertisement, which of the two categories does it fall? If it falls under potential unilateral contract, then that will be a unilateral offer. On the other hand, if it falls under potentially bilateral contract, then that will be invitation to treat. Of course, if you look at the wording, there's no doubt that this is the advertisement which will be subsumed under potentially bilateral contract, in the sense that it does not actually require a particular act to be performed in return for a stated promise of a reward and so on. So an offer. This is not an offer, because an offer is the expression of willingness, isn't it? Expression of willingness on the part of the offeror or promisor to enter into a contract on the terms contained in the proposal, if same will be accepted by the offeree. So here, if you look at it, you cannot say that this is an offer, because it is, there's no finality, because it said that it was 650, now selling 300. The fact that it was 650, now selling 300, meaning that it's possible by the time that, and say that selling like hotcake, by the time that you go, the price might have even shifted from 300 to something else, depending upon like the demand and so on. So you don't have like the finality. And again, the person has put a number there, but there is no promise or assurance by him that should you go, he or she will be able to get some for you, right? That he has like unlimited quantity and all that. So the finality, which is essential for constituting an offer, is lacking. And for that matter, it's not an offer. It's not an offer in the context of potential bilateral contract. Now let's look at B, a unilateral offer. Yeah, certainly, it's not a unilateral offer, because if you look at this, we don't see any particular act which is required of a person whom you want to respond to the advertisement. So that it will not do. Let's go to C, invitation to treat. Certainly, this is an invitation to treat, because if you respond to it positively, you have to come forward, make an offer, and then say may be accepted or rejected. Collateral offer. This has got nothing to do with the collateral offer, so we don't have to worry ourselves about it. Yeah, so I think the answer will be C. Did anybody get any other answer as far as 13 is concerned? Okay, all of you got, I think we don't have any dissenting opinion. There's no dissenting judge among us as far as this 13 is concerned. Let's go to 14. Which section of the Sale of Goods Act 1962 at 137 states that where necessaries are delivered to a person under an agreement which is void because of that person's incapacity to contract, that person is bound to pay a reasonable price for those necessaries. Yes, this is also the type of question we call the killer question, in the sense that you either know it or you do not know it. Yes, you may know the principle, right? The provision itself, but like you knowing the correct session number, that is the challenge. Now, if you look at the Sale of Goods Act, I've just opened page 70 of Mrs. Zona Hammond's book, and we know that is a section 2. Yeah, what provision? Okay, B, section 2. Section 2, 2 of the Sale of Goods Act 1962 at 137. And then the section 2.3 defines what the necessaries are. Of course, last year, the written part had a question on necessaries and all that. So, well, you cannot be sure whether anything of the sort will come on, but there's nothing wrong if you knew about it. So that's it. Okay, so that's the 14 is a B, section 2.2. Let's move on to 15. Which of the following was the majority decision of the Supreme Court on the directive principles of state policy in the case of Ghana Lotto Operators Association against the National Lotto Authority, or what is famously known as the Lotto case, one of the very famous decision. Yes, you know the directive principle of state policy, chapter 6 of the Constitution. When the 1992 Constitution came into force, it was a subject matter of controversy for quite some time. The view used to be that it was not meant to be justiciable, and for that matter, it could not find an action and all that. And another view was also that no, the entire Constitution is meant to be justiciable. So on that basis, because if you read article, if you read like the chapter 36, I mean chapter 6, article 36, I think that's the, yeah, if you read the article 36 of it, it says 36. No, sorry. If you read like 34, not 36, I mean chapter 6, article 34, it talks about the fact that the directive principles, which are stated over there, are supposed to guide all citizens, parliament, president, judiciary, council of state, cabinet, political parties, and other bodies and persons in applying or interpreting the Constitution or any other law, and in taking and implementing any policy decision for establishing or just in a free society, and so on and so forth. And then the president is required by Article 34 to be given what they call the state of union, or the state of implementation, what have been done to implement the directive principles of state policy. So there was that debate as to whether it is justiciable or not justiciable, and eventually it played out in the what we call the Lotto case, or Ghana Lotto Operators Association against the National Authority. And then the point was made that the directive principles are justiciable insofar as we have corresponding rights, or we have provision in other provision in the Constitution linked to that particular directive policy. If you can get something like that, then it is justiciable in its own right. So let's look at the options which we have over there. But I just wanted to read something briefly from Sir Dennis's constitutional law of Ghana, a little bit more recent work, Evolution, Theory and Practice of the Constitution, especially if you look at Article 211, where he make the point, especially 211, that all the where no adherence is made to the directive principle of state policy, the court may attempt to assume the resolution of a political question and principles of the directive principle of state policy when they are indeed not justifiable, but are presumptively justiciable. Yeah, so that was the point which was made earlier on in the NPP versus Attorney General, what do you call it, the 31st December case, where the court held that every position in the Constitution is justiciable. And for that matter, the Supreme Court did not exclude or the jurisdiction of the Supreme Court over political and directive principle objective. In other words, the 31st December case, there have been this debate that, yes, the Supreme Court cannot engage in discussing, political objectives of the state and all that. And that it was in that context that some of the judges expressed a view, justices that did that every aspect of the Constitution was justiciable. And then in the what they call like the NPP against Attorney General, what they call like the SIBA case, right? In the SIBA case, with the Supreme Court again held that the directive principles of state policy are not by themselves justiciable. So look at it. The Supreme Court has started saying that the directive principles of state policy are not by themselves justiciable. And then finally, in the Ghana Lotto Operators Association against National Lottery Authority, the Supreme Court stated the true position, and which is that the directive principles of state policy are presumptively justiciable and should serve as a guide in constitutional interpretation. So let's, with this understanding, let's go to the options. A, the directive principles of state policy are not justiciable. No, that's not what the Supreme Court said, the majority decision. The directive principles of state policy are justiciable if supported by another part of the Constitution. See, that there is a presumption of justiciability in favor of the directive principle of state policy. Okay, so if you look at the answers, the B, the contest is between B and C. Because like the A and the Lotto case, they never said that the directive principle of state policy are not justiciable. And as I quoted for you, they said that they are presumptively justiciable and should serve as a guide in constitutional interpretation. And for that matter, you will get C as the correct answer. But if you look at the SIBA case, the point had been made that the directive principles of state policy are not by themselves justiciable unless you can get a corresponding like the provision. But I must say that B, how the examiner put the answer, B and C can all be correct answer, right? B and C can be all correct answer if you read like the decision well. But yes, Francis. Francis?
Hello, sir. Good evening, sir.
Yep.
Please, could you assist us from the literature you are reading as to which one is the most recent decision, so that that could override the previous decision?
Okay, so in terms of chronology, let me give you I think the Lotto case was the last in the series. The 31st December case came first. Then the SIBA case next, not in the Lotto case. But let me give you the citation of those cases. So just let me pull the citations for you. New Patriotic Party. So the SIBA case is 1996-97, right? Majid. And then 31st December is 93-94.
Yes, sir.
Yeah, Majid, you are released. And then
yes, sir. Sir, I wanted to ask if the question
2007.
If the question was so in respect to this very question, if they were not asking the decision in the Lotto case, but they were asking the decision in the SIBA case, does it mean that B would have sufficed?
Yes, B will have sufficed. Yeah, because like just a minute. Yes, because like in the let's take like the Lotto case. The SIBA case. That's the NPP against the Attorney General. The court held that Directive principles of state policy are not by themselves justiciable. So, but if supported by another part of the Constitution, then it is. So B will have sufficed. Let's go to 16. Which section of the Sale of Goods Act? No, but okay, I mean, awareness. I think we've done this already. The necessaries. When we look at the one question, where necessaries are delivered. Okay, let's see if it's maybe a different rendition. Where necessaries are delivered to a person under an agreement which is void because of that person's incapacity to contract, that person is bound to pay a reasonable price for those necessaries. Haven't we 16, isn't it the same as the isn't it the same as 14? Or I think they are the same, or are they different? So that person, yeah, I think they are the same. And we've done that already. 17. A statutory instrument is okay. Yesterday we were talking about. I think we talked about this. Somebody even referred us to the ex parte Bombele case and all that, and we had a bit of a discussion on executive instrument, legislative instrument, and all that. So a statutory instrument is a session and act of parliament, no. A type of delegated legislation, yes. Another word for bylaw, no. It's not another word for bylaw. We will say that is a type of statutory legislation. And I will say that in Ghana, where, you know, as we saw yesterday, we have the LI, we have a legislative instrument, and then we have like the constitutional instrument, we have bylaws, and so on. But the statutory instrument is interchangeable with what we call the legislative instrument, except that in our jurisdiction, I think the most dominant usage is LI. But if you go to UK, right? If you go to UK, then over there, they don't say legislative instrument, they say SI, a statutory instrument. So that is just the difference. What is a ratio decidendi of a case? Judicial precedent, yes, we wanted to do a short lecture on that. Maybe we find some 30 minutes or 40 minutes to do a little bit of like a focus presentation or discussion of judicial precedent. But for now, we know that if you have like a precedent, the binding that which is binding in the precedent, what we call like the ratio decidendi. That is the principle of law, the rule, which is laid down in that case according to the material facts which the court has determined, or the rule which govern the decision which the court arrived at, as it were. So let's look at the option 18. Let me look at your responses. 18. Galazi, you mentioned Bank of Ghana against Laboni Weavers Club. Can you expatiate it for the benefit of the class? Galazi Tabe, can you raise up your hands so that I release you? Galazi Tabe. Please stop using the full names, okay? You can use your first name. So in subsequent class, if you don't use your full name, I'll not admit you into the class. You'll be in the waiting room till we finish. So you can say Ajua, you can say Kwame, that is fine, but don't use the full names. If you do that, I'll not allow you into the class. I will not use I will be admitting you one by one, okay? So just put a name there, Joa Kwame or something. And that one, I don't like the phone name, so it's not decent. For example, I want to call Galaxy Tab A, but he or she may not be the only person using that. There may be about 20 people using Galaxy Tab A 2016. So how do we actually get a person? And by the first time I made the useful input in which I would like he or she to share some more light on it for the benefit of the discussion we are doing. But you know yourself, so can you own up, please? Yeah, if you have like a nickname, that is fine. Yeah, I just don't like the full name. If you have anything, like a name can be anything, but don't use the full name because of like different people may be using like the same phone. So like, how do we get to know that it is you or the other person? But if you say like a barrister or you NS Antonio or anything like that, is fine. Okay, just for convenience of being able to call you, that is all, not for really knowing who you are. Okay, the person doesn't want to talk, so we're not forcing or her. Okay, so let's move on. Yeah, so all statements of legal principle made by the court. All statements of legal principle made by the court. No, that is not true. No, statements of legal principle made by the court, they are what you call like the dicta, right? If it is one dictum, and depending upon if it is a principle which is based upon the facts, the material, the essential facts as ascertained by the court, and for that matter is going to govern the ultimate decision which the court will arrive in that case, then that will be like the ratio decidendi. Otherwise, if it's just like a general statement of the law, we say like it's the obiter dictum. If there are plenty, obiter dicta, as it were. Or simply when you shorten it, if you just say like the dicta or dictum, it's just an abbreviation of like an obiter dictum or obiter dicta. B, the facts which the court found to be relevant in deciding the case. The facts which the court found to be relevant in deciding, that is tempting, but that is not it. Because the facts which are found to be relevant. So what principle of law is going to be stated on basis of that those facts? C, the legal principle on which the judicial decision was based. Yeah, so the C is the correct answer. Because if you like the facts which the court found to be relevant in deciding the case, that is not fully the meaning of the judicial precedent, as it were. I've seen that there's somebody hand is up for. Okay, see. Yeah, some of you will not talk. All that you're interested in is just the final answer. We want to have, that's why you call an interactive session. I want you to talk so that as we talk, we share knowledge and we correct any mistakes which they may be. Okay, so if you look at the Black's Law Dictionary, right, the 11th edition, which I have with me, if you go to page 1514, that is 1514 of Black's Law Dictionary. Ratio decidendi, this is how it's explained. Latin, the reason for deciding. It goes back to 18th century. The first meaning, one, the principle or rule of law on which a cause decision is founded. So you notice that the principle, that is legal principle on which the judicial decision was based, so on which the cause decision is founded, that is like the ratio decidendi. And then they say that many poorly written judicial decisions do not contain a clearly ascertainable ratio decidendi. So the rule of law on which a later court thinks that a previous court founded this decision a general rule at which a case must have been decided otherwise. Okay, so that is the ratio decidendi. And as I said, that if you are trying to determine if a judicial precedent is binding, you need to identify the ratio of that particular case. And having ascertained the ratio decidendi of that case, you have to find out the case which is currently before you. What are the material facts of that case? If the material facts of the case currently before you are on the same force or coincide with the material facts in the particular precedent in which you have ascertained the ratio decidendi, then what it means is that that precedent is applicable to the case before. And then we come to the next thing, the level of the hierarchy, right? What level does the court which lay down the decision in respect of which you've ascertained this ratio decidendi, you think that that decision is applicable to the case before you? What is the level of that court? Of course, we know that the Supreme Court decisions are binding on all courts in Ghana. Even the Supreme Court is also bound by its own decision, except that it has the power to depart from its decision where it considers it's proper or fit to do that. And what provision is that? Article what? That the Supreme Court decision are binding on one. The Supreme Court is being bound by its decision, except that it may depart from its own decision that it deems fit. What provision of the Constitution says that? Article 100 and what? What provision? Okay, let me see what you have. Francis? Francis?
Yeah, Article 126, Article 1253, 125.
I think the 1253. No, I think 129. Right? If you
1293, yes, please. 1293.
Yeah, so we start from 1292 and 3. So 129 at 129 clause 2 says that the Supreme Court shall not be bound to follow decisions of any other court, right? Shall not be found to follow decision of any other court. Then it goes on 3. The Supreme Court may, while treating its own previous decision as normally binding, depart from a previous decision when it appears to it right to do so. And all other courts shall be bound to follow decision of the Supreme Court on questions of law. So when it comes to questions of law, every court is bound by the decision of the Supreme Court. But of course, the Supreme Court is also bound by its own decision, except that it has been given the power to depart from its decisions when it considers it no longer a good position of the law, okay? So you have to keep that aspect in mind. And if you are, for example, you'll be given like a decision which is problematic and all that, and you are discussing and all that, you have to remember that first and foremost, the Supreme Court is bound by its decisions, except that it has been given the power that it can depart from its previous decision when it appears to be right to do so. When it appears to be right to do so means that the Supreme Court cannot just wake up and say that the decision in 24 against Attorney General is no longer a good law. Just that. It needs to tell us why it is departing from that. And that is why the Constitution is that when it considers right to so depart from it, then it will have to do that. But since it's a court of law, it must give like a reasoned position and not just arbitrarily move that we are no longer going to stick to this decision as it were. Yes, Francis? Is your hand up? Francis, is your hand up?
Yes, please, my hand is up.
Okay.
Please, can we then, based on Article 296(3), can we then say that from the cases you cited to us previously, that is MPP versus the AG, SIBA, then the Lotto case, can we then say
you mean Article 1293? You mean 1293?
Yes, please, Article 1293.
Right.
Based on the provision in Article 1293, that is the Supreme Court's power to depart from its previous decision. I want to have your confirmation.
No, but I would say that right now, the position of the law is more clarified. That yes, if you take that note, initially there was this attitude that declare directive principle of state policy as not being justiciable, right? And it is only meant to serve as a guide, and then the executive is supposed to report on what they are doing. But the Supreme Court is saying that no, there's a presumption that it is justiciable. So presumption simply means that, and I think it's not even it's not radically different from saying that the provisions of the directive principles per se are not justiciable in their own right, but where you have like a provision which has got like a corresponding provision in other parts of the Constitution, then you can conjunctively enforce them. So for example, if you are talking about, let's say, educational rights, right? And you have some provision in the chapter 6 speaking to educational rights, and then you also have like a provision in chapter 5, the fundamental human rights and freedoms. You can combine these two for purposes of enforcement. Otherwise, the directive principles of state policy are also interpretive tools of the Constitution and other laws. So that is the current understanding of the directive principles of state policy. Okay, so let's move on. All right. 19, the residual proprietary interest in land is also known as usufruct. Of course, this one, you know that is not true, isn't it? That is not true, because if you talk about the residual proprietary interest, it's not usufruct. Because usufruct, as we understand it, refers to the right of a member of a stool or skin or family holding the allodial title to land to enjoy portions of the land subject to his or her ability to reduce some into cultivation and so on and so forth. So yes, yeah, so that is not true. So the answer is what? It's false. Usually when you talk about like the residual, right? Residual, it has to do like the residue. So let's suppose that, and we may even say that the let's say you have like a 10-year, no, you have like a 50-year leasehold, right? And you have a 50-year leasehold, and you have created the 40-year sublease. So if you take the 40-year sublease from the 50-year leasehold, you are left with another 10 years. We can treat that 10 years as a residue, right? That is a residual because after that is what is left. Or we can also treat that as a reversionary, except that the rare reversionary will relate to the head lease, so that after the expiry of the 50 years, the land reverts to the original lessor. That would be like the rare reversionary. But let's say, in respect of you, like the holder of the sublease, I'm not like the creator of the sublease, you as like the sub lessor, because you have not given all your interest out, you still have the residue, and that in a way is also an example of the residual property interest, as it were. The power of Lands Commission to grant leases over acquired lands is by virtue of administration of Lands Act 1962 at 124. Okay, so we are confronted with the Lands Act again. Do you remember the provision which we said have been repealed, and then the provisions which we said are actually retained? Do you remember them? Is the Act 124 repealed or is retained? Anybody? Is it repealed or retained? I said that you should know it on your fingertips, isn't it? I am not going to write exams, so I haven't mastered the list of the repeal on my fingertips, since I can always open the provision in court and read it if I want. But you have to know it on your fingertips. Yes, what is it? Saint Mugai.
Is repealed.
Is repealed.
I remember the Rent Stabilization Amendment Act has also been repealed.
No, have you checked the list as whether Act 124 is repealed or not repealed? I haven't. I don't have my act readily around me, so I cannot. Look at the legislation.
13 acts have been repealed by the new Land Act 2020.
So do you have your act with you? Do you have the act with you?
No, I've read it before, but it's not with me now. But I remember land is part of the acts.
Oh, right. Okay. So if you look at the act and then the okay, administrator signed this up. So let's release my also here. Yes. The administrator, please. Go ahead.
Look, it's repealed, but my challenge here is that the Administration of Lands Act 1962 is Act 123, not
right.
124. I don't know whether the examiner brought the 124 to test.
Oh, right. Yeah, so again, as I keep telling you, sometimes some of the questions or some of the ways in which they try to examine you is a bit questionable, but that is not time for us to have that debate. So we just have to make do, because let's suppose that if, assuming it is at Act 1, 2, what? Administrator, what did you say the correct number was? Administrator, are you there? Okay, so if he's gone, let me look at my law. Saint Mugai. Yeah, so as he said, if we look at the laws, the Administration of Lands and 1962 Act 125. Okay, Mabeli, you can unmute yourself. Yeah.
Hello.
Yes, go ahead.
I have the Land Act 2020.
You have
Section 280. Yes.
Session.
Yes.
It's not clear. Can you open up your mouth? Hello? Hello?
Hello.
Yes, it's better now. Hey, yeah, we can hear you now.
Hello.
Yes, go ahead.
Yes, so should I read it? Section 282 of the Land Act 2020, Act 1036.
Right.
The following enactments are repealed.
Right.
A. The Land Development Act 1960. B. The Farmlands Act 1962.
Right.
C. The Land Registry Act 1962. And D. The Administration of Lands Act 1962, Act 123.
Okay.
So it has been repealed.
Act 1962, Act 1, 2,
2, 3, yes.
all right. Okay. All right. So it's been repealed. Okay. All right. But
yes,
as the administrator was indicating, we look at the question. we don't know whether of course, that is false, so long as the 124 is wrong. But the problem is that if you look at, yes, the Lands Commission has the power to grant over what acquired lands. No, okay. Yeah, but of course, so long as the 124 is wrong, then you have to say that everything about it is false. But again, the difficulty is like as whether the examiner made a slip. Maybe he thought that the correct decision was 124, and then he put like the 124 instead of the 123 as it were. But for now, let's assume that he's very much aware of what he was doing. So it is 124, and then that is false. Yeah, so we come back to the law of thoughts again. We come back. Mabel, you want to speak? Mabel, do you want to speak? Your hand is up.
No.
Do you want to speak? Okay, so let's go back to thoughts. Yeah, so this is also like a type of question which requires that you know it or you don't know, but at least all of us here, we know Donoghue and Stevenson. We know Donoghue and Stevenson, we know the Heaven and Pender, Dorset Yacht against the Home Office, Winterbottom and Wright. It was held that a person may owe a duty of care to another independent of a contract, provided it is reasonable that injury may result from want of care. Which of these cases lay down that proposition? Yes, who will tell us? Here's the testing your knowledge of the case law in the basic area of tort, the existence of duty of care. Donoghue and Stevenson, all of us know it, isn't it? Yes, but yeah, Saint Mugai.
I just see Donoghue versus Stevenson.
No, I want, yes, I know the answer is Donoghue and Stevenson, but I want us to test the correctness of that answer. We know Donoghue and Stevenson law that can lay down the general principle for existence of the duty of care based upon what we call the labor principle. So that is fine. What about Dorset Yacht against Home Office? What was decided in that case? Yes, what was decided in the Dorset against Home Office? Yes, in regard.
Remember the case to be some boys who went aboard a yacht. I whether they owed a duty of care to the supervisory authority. Unless I go back to it.
Okay, all right. Okay, so please check up the rest of the cases. Heaven and Pender predated Donoghue and Stevenson. But just in case you've forgotten, we know that Donoghue and Stevenson is the game changer as far as tort of negligence is concerned. Because before Donoghue and Stevenson, there was a tort of negligence, but the position of the law was based upon what we call like the a piecemeal approach. Piecemeal approach in the sense that only certain situations had the court previously concluded that a duty of care existed. And if you wanted to bring a case in negligence and will not, your case is not fit into any of those scenarios in which the court has concluded that a duty of care of owed, then you couldn't bring the case under negligence. But as you notice, that in 1932, Lord Atkin, in his beautiful judgment in Delegated and Stevenson, in application of the neighbor principle, made the point that a person can owe another person a duty of care whenever the relationship between them or the situation between them is said that if he does not have him or her in mind as likely to be affected by his action, and if he acts and the person is actually affected, when he ought to have had him or her in mind so as to be careful about how he conducted himself, then he will said to have breached a duty of care which he owes that person. And that is why he said that the neighbor principle we have in the, if you like the Bible, equivalent like the Samaritan, becomes the rule of proximity as to between you and the other party. Are you situated in such a way that if you did not heed or you did not take that person into account in doing something or failing to do something, and the person will be affected, then the law will fix you with a duty towards that person. Yes, Hubert. Hubert, your hand is up.
Yeah, I was thinking the answer is D, having a pender instead of Donegal and Stevenson.
Okay. Can you explain?
Yes, the reason is that with having a pender, the only test they gave was like the fact that if one does not use ordinary care and skill in such circumstances, then injury is likely to occasion to another person. But then with Donegal and Stevenson, it was a two-test approach. So they introduced the reasonable foreseeability as well as proximity. So that's why I'm thinking it's more of having and pender rather than the Donegal and Stevenson.
But the having and pender, if we look at the Donegal and Stevenson, allusion is made that I think Lord Isha made an obiter statement. And so an obiter statement does not constitute like the law, isn't it? For example, I've just opened a portion of the judgment, and in the precedent, there was an obiter suggestion by Lord Isha in Heaven and Pena that whenever one person is by circumstances placed in such a position with regard to another, that everyone of ordinary sense would at once recognize that if he did not use ordinary care and skill in his own conduct, he will cause danger of injury to the person or property of the other. A duty arises to use ordinary care and skill to avoid such a danger. However, this approach has been rejected by two other judges in the Court of Appeal. Lord Isha's attempt to reintroduce the principle in further obiter remarks in Le Rêve against Gold, in which he stated that having only established that there may be a duty, even if there's no contract, and that this duty arose if there was proximity between the parties was also unsuccessful. You see? So if you look at it in the Donegal and Stevenson, if you read the decision, well, like the full decision, you will notice that, yes, there's an acknowledgement that Heaven and Pender had foreshadowed or had given some hints to the general context leading to formulation of the general principle of duty of care in Donegal and Stevenson. But as I said, Heaven and Pender in that respect still remains like an obiter dictum, and that cannot be celebrated as a source of the general duty of care principle, which is rightfully attributed to Donegal and Stevenson. And Lord Atkin has actually won his place in the, in the history of law of negligence. Unless, Hubert, you want to deprive Lord Atkin of that glory, in which case you will agree. Okay, Otafo.
Doc, the reason why I think it's Donahue and Stevenson is because when you read the question very well, it says that a person may owe a duty of care to another independent of a contract. And we know that in Donahue and Stevenson, the one who purchased the ginger beer was not the one who drank it. So, yes, the manufacturers were trying to escape liability by saying that the one who drank the ginger beer was not the one who actually bought it. So there was no contract between them. So they were trying to free the court, tried to free the thought of negligence from what was known as the privity of contracts fallacy. So I think Donahue versus Stevenson really fits.
Yeah, Otafo, I like the very legalistic expression and the scholarly way in which you have put the last bit of your contribution. Okay, all right, thank you. Yeah, of course, this also reinforces some of us, our unhappiness with multiple choice exams, right, as far as law is concerned, especially some of these areas, they are highly debatable. And since you don't have like mathematical precision for some of these type of things, it becomes a bit difficult for you to insist, but we need to get the right answer. So I think that I will also say that the Donahue and Stevenson remains the most suitable response. But the heaven and pender is interesting proposition, except that it's largely an arbiter of the Lord Justice Isha, and it didn't go far. Yeah, so 2, consent or common benefit is referred to by most authors as the principle of voluntary non-fit injuria. I think yesterday or day before too, we had interesting discussion on the voluntary non-fit injuria as a defense to thought of negligence, which simply means like the voluntary assumption of what? A voluntary assumption of risk. So if it's a voluntary assumption of risk, and we noted, I think those who were, I came across an authority. Oh, I've just put it somewhere. But I'll get it and probably I'll take a shot and probably later on put it on the platform for you. You know, we had like a bit of a debate over one multiple choice question. I think regarding voluntary non-fit injuria, and later on I decided to look at some of the case law, and I got something which was very direct to what we're discussing. I thought that I should actually bring that to your attention, but I think that it has escaped me. Nevertheless, we know, and this is obvious, voluntary non-fit injuria means like a voluntary assumption of risk, and what it means is that the particular activity which the plaintiff is complaining he got the injury from, which is trying to blame on the defendant, is said to be inherently risky, known to the plaintiff, and yet he or she freely assumed the risk and went ahead to be part of it. Yeah. So is it about consent or common benefits? Is referred by most as the principle of voluntary non-fit injuria. I wouldn't say so. I will go for, because if you say like there's just a consent to what, I think it's too simple, isn't it? You need to qualify it. If you say that maybe like consent to something which is inherently dangerous or risky or something like that and so on, then maybe one could actually say that to some extent that is true. But as it is, I would say that I think it's false. Yeah, some people are saying that it's true. So Galazi Tabe, can you explain why you think it's true? Does it be? When you choose the answers and then you explain them, then it makes the class interesting. But if we are not just interested in whether A or B or C or D, we're interested in the explanations that we give. Because I said, it's the explanation which will help us to consolidate our understanding of things. Since there's no guarantee that you are going to have a repeat of any question, but at least if you understand the principle around it well, whatever question that it comes in that area, you'll be able to do it. So if you consented, yes. Yeah, okay. So if you take the Black's Law Dictionary and say that voluntary non-fit, there's no injury to one who consents. So consent or common benefit. But so can we simply say that because consent has featured in the question and voluntary non-fit injury means that you've consented to something which is injurious or something which causes injury to you. So we should just say that it is enough to use consent or common benefit as an abbreviation of the principle, voluntary non-fit injury. Will you go for that? Will you go for that? Hubert? Yeah.
I would say it's false, and my reason is this. For consent, right? And for consent, normally we can have consent on a bare level, but then for the defense of voluntary non-fit injury to apply, then that means that the plaintiff must have known the full consequences or the extent of the risk that is available. So that's why I think consent doesn't apply. Then for common benefit, we can have instances in which something is beneficial for both parties, but nonetheless, the claimants or plaintiff may not have consented to the doing of that thing. So I think the defense of voluntary non-fit injury should not be reduced to mere consent or common benefit.
Okay, thank you, Hubert. Okay, let's take other views. Saint Mugai. Yeah, Saint Mugai, yes.
Whether the common benefit was synonymous to the consent, or they operate at different levels in order to make a firm decision. What do you mean by common benefit in relation to voluntary non-fit injury? I'm going for B, false, but I just want to understand whether consent or common benefit are they synonymous or they are different. It's at different levels. What do you mean by consent under this circumstance?
Okay. All right, Hubert. You provided the explanation. Who provides the answer? Yes.
Common benefits is not the same as consent. That's why I said there can be instances where the particular action taken is beneficial to both parties, but nonetheless, one of the parties may not have consented to it. So taking the benefit of something doesn't necessarily mean that you are consenting to.
So when will the common benefit be a defense? But then that is what he wants us to answer. Saint, is that not the distance, your position?
That's my position. How and when can somebody be able to raise that as a defense? That for is born out of a reason of common benefit to us. When will one be able to raise that as a defense?
Okay. Yeah. Hubert. Okay, Barrister wants to come in. Barrister.
Yeah, good evening, Doc.
Yes, good evening.
I think I agree with what my brothers are saying, but if you look at the question, I think some time ago you told us that, or if not you, but I remember we had a discussion that for this particular kind of MCQ, if you try to stretch it so much to that extent, sometimes you can fall within the trap. The question is just trying to, I think, in my opinion, to set our knowledge under the understanding of voluntary non-fit injuria. Because if you look at the question, it qualifies by saying that it's usually referred to by most textbook writers or text writers or most authors, and which is true. Because the textbook I'm having here, I have with me Stephen Ofer, the law taught in Ghana. And if you open to one particular page, he described it as the literal translation of the Latin phrase voluntary non-fit injuria is no injury is done to one who consents. That's what he said. And if you also take another book, that is Commando on Law of Tort, the same thing, they all refer to as, it's simply known as like consenting to a particular conduct in the case of negligence. So I think that if we try to extend or stretch it to that magnitude, we may deviate from the answer. So based on that, I think that in this answer, the question, the answer should be A. Thank you.
Answer should be true. Right. Yeah, I appreciate the difficulty. Both schools of thought, those who say true and those who say false. Yeah, Barrister, your hand is up. Barrister, is your hand up?
Sorry, doctor. It's the previous hand.
Oh, right.
I'm sorry.
Right. But we see, we still come, if we say like it's true, Barrister, you did not explain the common benefit dimension. Because like, if it's just a consent, even we have a problem, like if we say like the consent simpliciter, because like consent to, if you have given someone, when it comes to tort of battery, consent is a defense, because battery means that there's absence of consent, isn't it? So if you can demonstrate that there was a consent, then the person cannot complain that someone has made an unpermitted contact with that person's body. And that is why I think that, but the probably what is making the difference is the information that by most authors, and it is debatable, but if you say by most authors, is it true that if you look at the Harry Streets, if you look at the Mackenzie, you look at the Winfield and Jowalos, Hepos and Matthews, Tony Weir, can we actually, these are the leading test writers on law of tort. Can we say that they take for granted that voluntary non-fit injuria is synonymous with consent or common benefit? That is where I have my doubt, and for which reason I want to, I'm tempted to gravitate towards saying that it is false. Yes, Theo, you can unmute yourself.
Yes, Doc. Good evening, Doc. I just put up in Wikipedia, and then there's this paragraph I just want to read to you. I think, it says that voluntary is sometimes described as the plaintiff, into bracket or in quote, consenting to run a risk.
Okay.
In this context, voluntary can be distinguished from legal consent, in that the latter, which the legal consent, can prevent some tort arising in the first place. For example, consent to a medical procedure prevents the procedure from being a trespass to the person.
Okay.
So as I think you've been mentioning, it should be consent to something, but just bare consent might not be synonymous to voluntary non-fit injury. It should be consent to some kind of conduct or something.
And also like the common benefit bit, because the common benefits, I don't get its relationship with voluntary non-fit injuria. Not necessarily. Yeah, so I think that for now, we will say that 22 is false. But of course, as I said, that if it is something that we are writing and you want to be able to explain your position away, that is fine. But this one is multiple choice. You have to just choose one, and that is the difficulty. 23, where applicable, the occupier must ensure that the work of the contractor is properly done in order to discharge the burden of liability. True or false? Yesterday we discussed occupier's liability briefly as part of the, I think, questions that either yesterday or a day before that, but one of the lectures that we recorded. Yes, true or false? Yesterday we look at the various types of we look at who an occupier is, we look at the various types of visitors and premises, and what the law says is expected of like the occupier. Now, in terms of the liability of the occupier, does it include ensuring that an independent contractor, or like, no, this one is not qualified, just like a contractor who comes onto the premises, does his work well? Does the liability of the occupier to ensure safety of others who are on the premises or those who come to the premises, does it include ensuring that contractors who come on or who have been given something to do on that premises actually do their work well, as it were? What did we say yesterday? I mean, those who were here yesterday, we discussed this a lot. And I even used our late Father Professor Fair's book to summarize some principles for you. Have you forgotten? I hope that you are the only one I see your face, so you are the person I'll be calling all the time. So, yes, so does the occupier of a premises, does a person's liability to ensure safety or ensure that harm does not occur to those who come to the premises, does it include ensuring proper execution of work by the contractor?
I stand to reason that yes, it includes ensuring that a contractor has done his work properly. So first of all, the occupier must bring a contractor that is for lack of a better choice of word, that is fit for purpose. I mean, a contractor that can do the work properly. So he must not be negligent in choosing the contractor. And even then, he must ensure that the contractor does the work well. And should he find any patent defects, then that means that he has to rectify it before any liability accrues. But then it is only in respect of latent defects that he's not liable. So I stand to reason that the occupier of a premise is liable to, he's liable to make sure that the independent contractor, or as they didn't qualify in this situation, the contractor, the contractor.
Don't mute yourself. I think the duty of the occupier is to ensure that he engages or he hires like a competent contractor. But hiring a competent contractor is different from ensuring that the work is properly done. Because if you have a competent contractor, if he doesn't do the work well, you have your legal remedy, isn't it? And why should can the occupier actually demand proper execution such that if the contractor did not do the work well, then we are saying that the occupier is liable for any harm or hazard which may be occasioned. Is that what we want to say? Hubert, yes? Yeah, I'm just testing the contribution that you made. Then when you finish reacting to that, then Bailey will come and then Oforiwa will also come. Hubert, are you there? Okay, I think we've lost it. Okay, so Bailey, let's hear you.
If you look at the case of Frances versus Cockrell, where the defendants had a stand and then the plaintiff came to, it was a game, and then the stand was negligently constructed and it collapsed, and I think he got hurt. It was held that there was an implied warranty under the contract that due care had been taken in constructing the stand. So they were held liable to the plaintiffs because the contractor he didn't contract the stand well. It was negligent. He was negligent in constructing the stand. So there's an implied warranty under the contract that due care had been taken in constructing the stand, in my opinion.
Okay, but that one, you were talking about the contractual obligation, isn't it? Oh,
yes.
Implied warranty.
Yes.
Okay, all right, so noted. Let's take Oforiwa.
Okay, Doc, I'm just adding up to what the lady just said.
Yeah,
in that particular case, the Frances and Cockrell, because it was an independent contractor who constructed the stand, the court said that that duty extends to that particular independent contractor who was employed to erect the building. So if the construction is done without due care, the employer will be liable. The employer here is the defendant, which is Cockrell, the one who employed the independent contractor. So it means that the employer is supposed to ensure that the contractor has done the work properly or has done the work well. So I'll go for 2, which is A.
Okay. All right, okay. 24. Which of the following statement is true of the doctrine of negligence? A, what a reasonable man will foresee determines the existence of a duty. And what the reasonable man will do determines the scope of the duty. Francis, you have something different? Francis?
Yes, please.
Yes.
Yes, please, sir. I guess you are convinced or you subscribe to the expatiations that the two ladies have given us. Hence, your move from 23 to 24. Should that be my thinking?
Yes, because of the authority of the Francis and the Cockrell. And I just quickly look at that authority myself. And what I am reading, I think is consistent with the trend of responses which the two speakers have actually given. And that is why I didn't want to belabor the point. On the other hand, if you have like a contrary view, I would like to listen, because what I have, right, the material I have now what you call the contractual obligation owed by occupiers or as implied warranties. And you will notice that most of them, just listen to this bit, okay? Quote, for a significant number of occupiers, including those occupation of roads, interchanges, footpaths, shopping centers, supermarkets, residential premises, sporting ovals, parks, and other public areas and facilities, entrants are not usually granted access to the premises in exchange for valuable consideration or reward. In circumstances where entry occurs on terms requiring exchange of consideration or reward, an occupier owes a separate and more onerous obligation to the entrant than would otherwise be blamed. This more onerous duty, which has not been subsumed within a broad brush approach, has been described by the Court for Appeal as an existing one. It flows directly from the contractual obligation that arises between the parties. Then you go on to cite the case of Francis and Goko. It is tried to say that in any contract for exchange of goods and services for a reward, certain obligations may be implied to the contract necessary for the efficacy, whether or not the parties have specifically agreed to be bound by these terms or not. The exacting duty referred to above arises from the implied contractual warranty, as articulated by the Chief Justice Chief Baron of the Exchequer in Francis and Cockle as follows, quote, when one man engages with another to supply him with a particular article or thing, to be supplied to a certain use and purpose in consideration of pecuniary payment, he enters into an implied contract that the article or thing shall be reasonably fit for purpose for which it is to be used and to which it is to be applied. So like if you move on, you will cite another case, Macklin and Segar, and just try to build on the point that there is that implied contractual liability on the part of the occupier vis-a-vis a contractor. Of course, it will be like an independent contractor, as it were. Yeah, so I think that is how we will settle that issue. But I will urge all of you to read the Francis and Cockle again. We can reopen the debate on question 23 in our next class, but let us quickly clear the remaining multiple choice so that we can end the class and we can make some progress towards the essay questions and just move on. Yeah, so B, what a reasonable man will foresee determines the scope of a duty. And what a reasonable man will do determine the existence of a duty. It's A and B. I didn't know repetition, or you don't see that. I think A and B are repetition, no? But it's not. My eyes are deceiving me.
No, please.
A and B are different.
They are very different, sir.
They're different. Okay. What a reasonable man will foresee determine the existence of a duty. And what a reasonable man will do determine the scope of a duty. Okay, let's look at the B. What a reasonable man will foresee determine the scope of a duty. And what a reasonable man will do determine the existence of a duty. I think the A and B are the same, no? I don't see that. Where lies the difference? Look at the A and B. Can you tell me the difference?
In B, you see reasonability determining scope.
No, I want to, so like the line, I want to be sure, because my eyes seem not to be seeing the difference. Or foresee determine the existence of a duty, because you have the same determined. Oh, right, understand.
So you see foreseeability determining scope, right, and then in another.
Okay, yeah, you're right. Yeah, they are not the same. They are not the same, but initially my eyes could not see the difference. Okay, see, what the reasonable man will foresee determine the existence of a liability. What the reasonable man will do determine scope of damages. D, what a reasonable man will foresee determines scope of liability, and what a reasonable man will do determine the existence of the damages. Okay, so let's start from A. Francis, your hand up.
No, please. I think it's an old hand.
Oh, right. Okay.
But I will come back with my answer.
All right. Okay. So let's analyze the 4 so that we determine the correct one. Okay. So let's take A. What a reasonable man will foresee determines the existence of a duty of a duty of care. Is that the case? And what a reasonable man will do determines the scope of the duty. No, the scope of the duty does not depend upon what a reasonable man will do. That is not our understanding of the thought of negligence. The existence of the duty of care, of course, we talk about the reasonable foreseeability, right? Proximity and all that. But in terms of like the scope, yeah, Francis. Okay, Francis is not talking. Okay, let's say Odai. Odai is gone. Yeah, Francis, your hand is up. You can talk.
So I think I'm convinced with B, but then we can examine the other ones. Then I can explain my stand with B.
Oh, right. Okay. So Henry Odai. Henry. Yeah, Henry, you can talk.
Yes. I was thinking that was A.
A, can you help us to understand why you think A is the correct answer?
For the foreseeability, I was thinking of either Donahue Stevenson.
But what about
so the foreseeability? Come again?
But the scope of the duty, does it depend upon what a reasonable man would do?
That's what I felt. Okay. Because what the reasonable person would do in a circumstance would determine whether the duty was breached or not.
Oh, okay.
When you come to the second part, reasonableness of
the standard of care.
Establishing, yeah, exactly. Establishing whether it was breached or not.
With the standard of care. Okay, so of course, if you are equating standard of care with scope of duty, then you are right. You are talking about like the reasonable man test. That okay, but we haven't concluded on that yet. We've taken note.
Yes. Sure.
Right. Francis, you want to react?
Yes, please. I'm rather of the opinion that foreseeability determines scope, and then what you do, what one does, is based on the existence of duty. So duty must you act based on existing duty that you owe, and then the scope of what you the scope of your liability is determined by foreseeability.
Right.
That is why I would rather go for B instead of A, because we see the foreseeability, which has a connection with scope, and then duty that is based on the the existence of duty determines or informs the action.
No, but if you take the Odai, right? Odai's explanation of the scope of duty, I think, gravitate towards our understanding of what they call like the standard of care. And you know, the standard of care is what is used when we are trying to determine whether there has been a breach of the duty of care. Before you can make a determination as to whether the duty of care has been breached or not, first of all, we need to know what's the appropriate standard of care. And the appropriate standard of care was like how big or how small was the particular duty, or what was expected of the tortfeasor, the alleged tortfeasor, and the circumstances. So if you juxtapose the action of the tortfeasor against that standard of care, then we'll be in a position to know whether the tortfeasor breached the duty of care or not. So right now, question is the scope of duty synonymous with the standard of care, or the scope of duty should rather be understood in the sense of like the existence of the duty of care? I think in analyzing A, I think that is where our mind should be going to. So let's go to B. Francis, you are the sponsor for B, isn't it? So why did you choose B? What the reasonable man will foresee determines the scope of a duty, and what a reasonable man will do determines existence of a duty. Yeah, so Francis, you opted for B. Why?
Yes, please. So I am of the opinion that foreseeability has a connection with scope, because foreseeability, in other words, means contemplation. What the reasonable man will have in contemplation. Will the ordinary, will the reasonable man have the third party in contemplation as he does his work or he doesn't do his work? So having the person within your contemplation now brings into the picture scope. That is how far or near. That is where my argument or my conviction is coming from. That if you're talking about the foreseeability, then you have foreseeability of the other person, your actions affecting the other person. Then that one determines the scope. That is how wide or close your duty lies.
But let's go back to Donoghue and Stevenson. Okay, at least Donoghue and Stevenson, LeBlanc, Caparo and Dickman, right?
Sorry for barging in, sir. But you see the definition of the neighbor principle,
yes.
The neighbor principle as established and Donoghue and Stevenson.
Yes.
Is talking about proximity. That the fulcrum of that one is hinged on proximity.
Yes.
And proximity, then you are talking about scope. So scope and proximity could be used interchangeably as to how far or near the person is to you, such that you must have that person in contemplation in doing your actions as to whether your actions are likely to affect the person or not. And so that is the connection or the nexus I'm drawing between foreseeability and then the scope of duty.
Right. All right. Okay. So let's look at the other sentence. Then we analyze them. What a reasonable man will foresee determines the existence of a liability, and what the reasonable man will do determine the scope of damages. Of course, the scope of damages does not depend upon what the reasonable man will do, isn't it? It's also based upon like what we call like the foreseeability test. If you are looking at like the award of like the damages for tort, the foreseeability test, and that is not necessarily coterminous with the what the reasonable man will do. But what was foreseeable at the time that the tort was committed. Yeah. D, what the reasonable man will foresee determines the scope of liability. And what the reasonable man will do determines the existence of damages. So C and D, what is the difference? What the reasonable man will do foresee determines the existence of a liability. And D, what the reasonable man will foresee determines scope of liability. And what the reasonable man will do determine the existence of damages. Yes, Hubert and then Oda.
Yeah, so I'm also thinking is A. What a reasonable man would foresee determines the existence of a duty, and what a reasonable man would do determines the scope of the duty. So if you look at the test in Donegal and Stevenson as well as the Caparo industry, in terms of determining the existence of a duty of care, then there must be what reasonable foreseeability. So that's the first point we have to take note of. When you reasonably foresee that your actions are likely to cause injury to your neighbor or the person that is closer to you, then that means that there exists a duty of care. But then what you will do after the existence of the duty of care will not determine the scope of the duty that you owe to the person. So I think that it is not what you do that will determine the existence, but rather what you do will determine the scope of the duty after you've known that you owe a duty of care to the person by reason of the existence of the foreseeability.
Okay. All right. Thank you, Hubert. Let's take order.
Okay. Back to what I was saying. I think that in this scenario, the first step that is normally done is to first establish the duty. So you have to establish the duty first before you can go on and then talk about scope of the duty. So without establishing the duty, you can't talk about the scope. So for establishing the duty, when we look at Donahue Stevenson, it talks about reasonably foreseeing that your neighbor will be injured.
Right.
Which is what is used to establish the duty first.
Right.
Before the next step is determining the scope of that duty, which is the standard of care.
Okay. All right, Henry, thank you. So let's take a jump fee. If he has a contrary opinion to.
Yes, so I will go with B, because when you take foreseeability, it means that you are foreseeing, you are looking to the future, what will happen in the future. So if, for instance, we take the issue of risk, if you foresee that the risk involved is going to be too high, and to mean that the standard of care that you need to provide must be also equally, higher. So if you equate standard of care to a scope of duty, okay, it will mean that.
Nana, sorry to cut you in. The one which is letting me be convinced that E is not correct answer is attempt to let the existence of the duty of care dependent upon what the reasonable man will do. I think that is what is problematic. And as the other contributors have said, let's go back to the basis. If we go, maybe like when you finish this class, you can go back and read Donegal and Stevenson, and you will get to know that in terms of the general principle that the court enunciated regarding the existence of duty of care, is more about if you do not, for example, do not have in mind that your acts or missions may affect someone who, by reason of his relationship or position to you, is going to be so affected, then we say that in that context, you owe that duty of care. And then when we have concluded there's a duty of care, and you want to determine whether in the particular situation you live up to that duty of care or not, we need to find out how will a reasonable man placed in your circumstances will have behaved. If a reasonable man will not have done what you did, then we say that you have breached the duty of care, as it were. Yes, but I will say that while we are endorsing A, I would like everybody to go and read Donegal and Stevenson to confirm whether you are really convinced about our current choice of A, or you bring up another answer, and then we will look at it. So let us move on from question 24 with the advice that you are going to read Donegal and Stevenson. So let's take question 25. Article 295 of the 1992 Constitution, Article 213 of the 1979 Constitution, Section 281 of the Land Act defines two land to include family land, true or false. And so again, this is the reason why I was telling you that the interpretation session of the Land Act, of course, as the Constitution, I've advised you already that you should be reading the Constitution every day. And about a month ago, when I gave the advice, those who heeded, I'm sure you finished reading the full Constitution. You're almost finishing the second round of reading. Then you start like the third round before you write your exams. And the Land Act, the last time, we even spent almost about 40 minutes trying to discuss the interpretation session, if you remember. So here, that knowledge is being tested that if you look at the definition of true land, is true land defined to include a family land? Certainly, if you look at Article 295, right, which I'll be able to open mine at the page 184, that the true land includes any land or interest or right over any land controlled by a stool or skin, the head of a particular community or captain of a company for the benefit of the subjects of that stool or the members of that community or company. So certainly, you cannot say that, yes, Harry, or die. Henry, okay, all right, okay. Now, has anybody got his Land Act? Can you look up the meaning of definition of true land for us? Section 281 of the Land Act. Do you have your Land Act with you? I don't have mine readily around me. What does it say? Section 281 of the Land Act. Yes, the lady. Yes. Yes, what does it say? For you,
Okay, docs. True land includes land or interest in or right over land controlled by a stool, skin, or the head of the particular community for the benefit of the subjects of that stool, skin, or members of that community.
Right. So if you look at that definition, it does not include family land. So the answer should be false. And look at, can you tell us the definition of family land if it's in section 281, the interpretation section? Family land. Can you tell us, please? Look it up. If you see it, go to the F column. You know it's arranged in alphabetical order. Have you seen it? Oforuwa, are you with us? Are you there? Oh, then we've lost okay. Whoever, yes, Deck. Yes, you can.
Yes, sir.
Yes.
They say that family land means land in the interpretation.
Yes.
So the family land means land, the allodial title, to which is held by a family for the benefit of the members of that family in the accordance with customary law.
So in that case, 25 will be false, because if you look at the definition that I read from Article 295 of the Constitution and what Lady Oforuwa read from the Land Act, Section 281, it does not include family land. Then let's look at the 26th. But again, I'll remind you that you should pay attention to some of these interpretation session as it were placed. And I think there's a question we also came across earlier on, and the question said that the statutory instrument includes something, and we were not able to, nobody referred me to the Constitution. If you go to Article 295, which is the interpretation section of the Constitution, certain words and phrases are defined over there. So statutory instrument, for example, is explained over there, and we've had the question on it already. So if you remember question number, I think earlier on we saw question number, question 17, okay, that a statutory instrument is. Now, let me read the definition of the Constitution so that we are sure of the authoritative position. Statutory instrument means an instrument made, whether directly or indirectly, under a power conferred by an act of parliament or a decree or a law. So that is it. So an instrument made, whether directly or indirectly, under a power conferred by an act of parliament or a decree or a law. And that is why we said that it's a type of delegated legislation. In fact, what we have quoted here is the essence of what the delegated legislation is. Well, let's quickly go back to, we should be finishing, it's midnight already. I think we need to end the class. Let's look at 26. And okay, quickly, we need to end the class, it's midnight. Which of the following orders is the High Court precluded from issuing under its supervisory with respect to a chieftaincy cause or matter? Habeas corpus, prohibition, quo warranto, certiorari. Okay, anybody? Yes, the lady, your name is not there. So, yes, but you can mute yourself. Please, next time, just indicate any name so that you can mute yourself. Oh, okay, so let's do the Isaac attend the lady. She put her hand up mistakenly.
Yes. Yes, Doc. My understanding about the matters, cause of matter affecting the chieftaincy with the Chieftaincy Act, I think it's section 76. Then of the Chieftaincy Act talks about matters affecting chieftaincy.
Right.
Then the Courts Act, to, I think section 117, talk about committees of the various houses of chiefs are the ones that determines matters affecting chieftaincy.
Okay.
So it is when issues are not being able to resolve at the National House of Chief level that with the leaves of the National House of Chief, the Supreme Court is the appellate body. So going by that, prohibition, I'll go for prohibition because matters affecting chieftaincy, the primary jurisdiction, the one that have the primary, as in if it happens, those ones that are supposed to handle is not immediately the courts. It is the judicial unit of the chieftaincy institution that handles it. So based on that one, I think that the court doesn't have the functions or with prohibition to prohibit it from anything because it's a traditional matter that's supposed to be handled by the Judicial Committee of the House of Chiefs. That's why I'll go for prohibition.
But what about quo warranto?
Well, that one is also a tricky one, too. It's a tricky one there. So, yeah, it's a tricky one there because quo warranto is more or less like.
I think that the answer should be habeas corpus. What is habeas corpus? Habeas corpus has to do with
to produce a body.
Yes, so
yes.
That is obvious, isn't it? Because the chieftains, do they detain people?
No.
Do they keep people somewhere? No. And So it will be habeas corpus. Prohibition can be applicable where, let's say that a judicial, let's say like the traditional council or a regional house of chiefs or whatever, is doing something which it doesn't have like the authority to do and all that. Even like the house of chiefs, you go to like the Supreme Court and all that,
Yes.
But the regional house of chiefs is doing something obviously doesn't have the power and so on and so on. In terms of supervisory jurisdiction, the High Court has supervisory jurisdiction over it because it's part of like the inferior or lower adjudicating bodies, as it were. And then co-warranto, by what authority are you doing what you are doing and so on. Certiorari, as we've explained, you quash the decision or the order. But the habeas corpus, in my view, will be that which is not really applicable in exercising this supervisory jurisdiction over a chieftaincy cause or a matter. So let's go on to the last one, the 27. Then we'll probably end this midnight. The High Court of Ghana has supervisory jurisdiction over all lower courts and adjudicating tribunals. The main exercise of that jurisdiction issue any of the following, except this one, waste time. The answer is summons, isn't it? We've already discussed co-warranto, mandamus, and habeas corpus. And look at it. The 26 and 27, they are all talking about supervisory jurisdiction. But because 26, the supervisory jurisdiction relates to a chieftaincy or a cause or matter. That is why we said that habeas corpus is not applicable. But as far as jurisdiction over the other lower courts and adjudicating tribunal, because they have also power to detain and so on and so forth. That is why habeas corpus is applicable, but summons is not applicable because summons relates to either rate of summons or subpoena ad tecum or subpoena ad testificandum, as the case were. Okay, so thank you very much for coming and have a very good morning. Later on, we'll meet again. Thank you very much.
So quick, shouting out the stuff.